Good afternoon, everybody. After an excellent lunch, we're going to try and now keep you awake. I feel always following Mike Schmidt, it's a little bit like following the Lord Mayor's show, as we say in London. You will notice that it is only Brits and faux Brits like Mike who wear ties on occasions like this. You'll also notice it's the same tie. No, he didn't lend me his. Now, this afternoon, what we're going to be doing is looking at the civilianization of warfighting, and in particular, the concept of direct participation in hostilities. And Mike gave us a very good lead-in this morning. Conflict has changed. We all know that. Certainly, as an old Cold War warrior, I have watched as the world that we thought was going to be the brave new world in 1989, 1990 has seemed to dissolve around us. And the change of conflict has put pressure on some of the most fundamental principles of the law of armed conflict. One of those is the principle of distinction. In the olden days, we spoke of the battlefield, and later of front lines and rear areas. I remember the story from the US Civil War, or as Hayes Parks describes it to me, the War of Northern Aggression. I think it was the Battle of the Bull Run, where everybody came out and the forces were fighting down in the valley. And the people came out from the local towns and sat on the hilltops with their picnic baskets and their bottles of wine and watched the gladiatorial combat going on down below. The sort of Colosseum in the round, if you like. Those days have changed. Today we talk about a battle space, and even space is probably the wrong word, because that seems to have a geographic meaning. The battle is everywhere. It's all around us. And in that space are a myriad of actors, ranging from regular armed forces right through to peaceful civilians. This spectrum runs through irregular forces and groups, government employees, private security and military companies, and civilians who just decide for the heck of it to join in the argument. But this creates a serious problem when it comes to the principle of distinction. Civilians are protected. We know that. But who are civilians? And what do they have to do to lose that protection? Can they regain that protection? And what are the consequences of losing it? Now, the ICRC, and I've got the real article here, not just the slide, the ICRC produced their study into direct participation in hostilities. I think it is uncontroversial to say that this is controversial. A recent edition of the New York University Journal of International Law and Politics, edited by our own Stockton professor, Derek Jinks, and Ryan Goodman, who's sitting here on the panel, produced 4 critiques of the study. They came from Canadian, US, and UK government officials, and Mike Schmidt. There were 2 former Stocktons and 1 future Stockton. And there was also a detailed, and I mean detailed, riposte by Nils Melzer, who's also on our panel today. Our other panelists, apart from Nils and Ryan, are Brigadier-General Blaise Cathcart, and we're extremely grateful to him for stepping in at less than a week's notice to cover for Ken Watkin, the incoming Stockton professor, who, as we know, is otherwise engaged, and Françoise Hampson, who will, I hope, approach the subject from a slightly different position, looking in particular at the interplay between Hague law, Geneva law, and human rights law. Their bios are in your documents, and I don't intend to go right through them, partly because we'd be here all night if I had to read them out. It's a very distinguished panel. And I could not ask for better people to try to work you through this extremely complex subject. What I want to do, I hope, is leave plenty of time for discussion. The running order is going to be Ryan, Blaise, Françoise, and then after we hope a break, and I'm hoping there's going to be coffee. Coffee? It's tea time, UK, but dare I mention that in this place. And finally, Nils Melzer. So let's get the show on the road, as they say, and I'll hand over to Ryan Goodman.
So thank you very much for having me here. It's great to be back at the Naval War College. The topic that I'm going to be discussing is what is otherwise known as Section 9 of the Direct Participation in Hostilities report. The heading of that section is the restraints on the use of force. In other words, it kind of jumps ahead, and once you've made a determination of who is the member of the armed forces, who might be a combatant, who is a direct participant in hostilities, whether or not those who are attacking those targets are under any restraints under the laws of war in terms of the degree of force that they use. The conclusion that is reached by the ICRC's report is, quote, the following, and this is what I'll be analyzing. The kind and degree of force which is permissible against persons not entitled to protection against direct attack must not exceed what is actually necessary to accomplish a legitimate military purpose in the prevailing circumstances. In other words, this is a rephrasing of Pictet's famous statement that, quote, if we can put a soldier out of action by capturing him, we should not wound him. If we can obtain the same result by wounding him, we must not kill him. If there are two means to achieve the same military advantage, we must choose the one which causes the lesser evil. Okay? So that's the subject of my discussion. It's arguably one of the most controversial aspects of the report, both because of its substance and then its relevance to the DPH standard. I'm going to be dealing primarily with its substance. The subject of my analysis is not just the report, but also the colloquy that has ensued, in particular between Hayes Parks and Nils Melzer in the NYU Journal, and also with Mike Schmidt in the Harvard National Security Journal, all taking up this section of the DPH interpretive guidance. My claim that I'm going to try to put forward to you, and that I really do invite your criticisms, because this is me trying out the ideas in the first instance, is both a positive claim and a normative claim. My positive claim is that the ICRC report indeed may be a leap from where the law exists to where the law could be. It might be a leap, but it's not as far a leap as critics have contended. It's not as far a leap as critics have contended. The normative question is whether or not we should make that leap. And I think that question hasn't been focused on. It's not really focused on very directly by the existing commentary. But where should the law go, even if we understand where the law is right now? I do think that the greatest support for the interpretive guidance is when the conclusion that they reach is restricted to highly specified and limited conditions, which the interpretive guidance does, in fact, place many of these conditions on that conclusion. The first is an explicit condition that the interpretive guidance states, which is that there's no obligation on the part of the attacking party to assume increased risks to its own forces in order to protect the life of an adversary, so that the attacking force need not assume any modicum of risk to its own forces. In other words, it's not necessary to protect even a single soldier. One could take it that literally. And therefore, if it's balancing the increased risk to the target versus the life of a single soldier, then the life of the single soldier would displace it. But if that's not in the equation, and it's otherwise unnecessary to attack the person in order to kill the person in order to disable them, then this rule would be applied. So that's the first, that there's no obligation to assume an increased risk. The second is that the conclusion or standard is applicable most especially, if not limited to, circumstances in which the attacking force exercises effective territorial control. Effective territorial control. So this answers in significant part, I think, the question of impracticability, that a standard like this is not practicable, that armed forces would ever be able to manage this kind of continuum of force. The answer might be in part that the conclusion is reached that it's on a spectrum, and the spectrum especially takes place when in counterterrorism or non-international armed conflict occupation settings, when it increasingly shares the characteristics of law enforcement And increasingly in the 21st century, as conflicts and the use of force takes on those features in which it looks more like urban security forces in many countries around the world that have taken place in the last decades, but it's in an armed conflict situation, it might be that it's more practicable in that situation, but it's a constraint or condition placed on the application of this standard. The third is that the situation must be one in which it's manifestly and completely unnecessary to kill the individual. Manifestly and completely unnecessary. That's not embedded in the ICRC's guidance, but I would suggest that that might be one in which there is the strongest support for the conclusion. In other words, the idea that there is a continuum of force, a la Pictet's statement, is motivated more by the hypothetical of what happens when Padilla steps off the aircraft in O'Hare. And can he then just be taken out? Or if it's already that he's primarily essentially defenseless, does that mean that we should use less, that there's an obligation to use less force just to apprehend him, because he can be apprehended and it's unnecessary to kill him? In other words, it's motivated more by that scenario. It's not motivated by combat situations or the idea that in combat or active hostilities, soldiers should be thinking about shooting to wound rather than shooting to kill. And the report is fairly explicit about that, and Nils is fairly explicit about that in his rejoinder to Hayes Parks. The last condition or parameter is the level of authority or responsibility. So the question is whether or not we're talking about the obligation that pertains to the individual soldier, or rather it's way up the level of command to commanders or superiors and state authorities themselves who are involved in the planning and the control of the action, not the individual soldier on the ground. And that might make a big difference about how you think about both where the positive law is on this question and then the normative question of where you think the law should go. So you might actually accept the ICRC standard only insofar as it applies to the commanders, not to the individual soldier. The individual soldier should not have to make these kinds of split-second decisions about whether or not they should wound versus kill or arrest versus wound, but rather that should be something that is left up and is an obligation on the part of the command as to whether or not they're putting their soldiers in a position in which they're using too much force than is necessary. So that might be one way of getting at this. So with those four conditions, I do think it is important to recognize the ICRC's guidance as a compromise position. So you might even think that it should be celebrated for not being as extreme as what otherwise could turn out in this situation. Let me give you two examples of why it's a compromise position in my view. The first is the effective control standard. What I'm about to talk about in a little bit is support for the ICRC's position that can be found in the additional protocol itself with respect to, for example, the definition of hors de combat, who is actually outside of the zone of combat or taking place in hostilities. And that position doesn't have a sub-element of effective control. It would apply to all people in all kinds of situations, potentially. The ICRC puts an additional element or constraint that we're talking about very specific kinds of circumstances in which there's an exercise of control or territorial control. So it's a compromise position from that extreme. The second is that it does not engage in a proportionality analysis. It's not a balancing of the threat to one's own soldiers. Should the armed forces who are attacking internalize some of the risk versus the risk to the enemy armed forces or to the individual that's being attacked? Rather, it's more of a categorical rule, as I've already alluded to or described. That is, if there is a risk to one's own soldiers, then we're not in the field, we're not in the zone of having to take into this consideration. That's in contrast to the Israeli Supreme Court decision. The Israeli Supreme Court decision at least implies more of a balancing test so that it would be fair to enter into the equation what is the risk to one's own armed forces versus the injury or the use of force against the target of attack. To take a quote out of the Israeli Supreme Court opinion, the quote is that the arrest, quote, arrest, investigation, and trial are not means by which not means which can always be used. At times it involves a risk so great to the lives of the soldiers that it is not required. In other words, it's a balance. Sometimes it will be a risk to the lives of the soldiers that is required, is the obvious negative inference that one would draw from that. And the ICRC's guidance, at least my reading of it, is that it doesn't include that kind of a balance. So now I just want to try to evaluate the arguments for and against the ICRC's position and the Pictet thesis of this continuum of force. And let me also, I guess, drop one footnote and say Nils, in his reply to Hayes Parks, does not say that they are doing a continuum of force, but there is a citation to Pictet in the guidance itself. Let me first outline what I think are the major weaknesses of the ICRC's position. The first major weakness is that aside from limited exceptions, there appears to be a lack of specific provisions in treaty law related to this standard. In other words, with a limited exception, I might think of, for example, the superfluous injury and unnecessary suffering provision of the additional protocol. Might be the most on-point standard, but primarily it relies on general principles of humanity and general principles of necessity, or otherwise interpretation by inference. For example, Mike Schmidt does give an example of this in his Harvard piece. In the civilian context, we have a rule, for example, in Article 57, which says, quote, when a choice is possible between several military objectives for obtaining a similar military advantage, the objective to be selected shall be the attack on which may be expected to cause the least danger to civilian lives and to civilian objects. And the idea is there's no counterpart for military lives or military objects. So it lacks that kind of definite, concrete, direct legal provision. Second weakness is state practice. So we might say that there's actually fairly paltry state practice, and if you look around the world, the ways in which militaries are being trained, soldiers aren't exactly being trained, that they need to only try to wound, not kill, and only try to injure, and if they do not use a form of lethal force, only try to injure instead of using lethal force, and only try to arrest instead of injuring. That's not the training of many military forces around the world, so it lacks that kind of state practice. The only three forms of state practice that are used in a sense to support the conclusion most directly have problems. The first is the Israeli Supreme Court opinion, which is clearly, I think, in support of the ICCR's conclusion. It's very consistent with it. Hayes Parks makes the argument in his piece that, in fact, the ICRC's guidance was galvanized by the Israeli Supreme Court opinion. Nils, I think, correctly responds by saying that, in fact, that can't be true because the 2006 meeting of the experts, in fact, takes place in November, and the Israeli Supreme Court opinion takes place in December of 2006. But for me, that actually invites another kind of concern, which is that they already reached their tentative conclusions without the Israeli Supreme Court opinion. So it might be well and good that the Israeli Supreme Court opinion is consistent with it, but it wasn't pre-existing precedent. Precedent would have to precede presidential support. Another one is in Nils's response to Hayes, there's a reference to Colombia's military manual, which was issued in December 2009, and a reference to the fact that the Colombia manual repeatedly refers to the interpretive guidance. Once again, that's fair enough insofar as it goes that the Colombian manual seems to support and is consistent with and embraces the ICRC's guidance, but it's not good support for the fact that it didn't come before the guidance. So it didn't precede it. It's not a foundation for it. Then the last one is the UK manual, which also has language that's a little bit more ambiguous, but does, in my view, seem to support the same standard that the ICRC articulates. Mike Schmidt, in his piece, says that that interpretation of the UK manual has been repudiated by the main author of the manual. So that's one of the problems with it. I don't think that the author of a manual gets to be the final authority of it after it's written, just like no author of any poem gets to be the final authority of its meaning or interpretation, but that is a concern for reliance on the manual. So that's outlines the second area of concern, state practice. The third area of concern is something I've just started to think about. I'd love to invite discussion either during the session or otherwise, which is indirectly inferring what we know about this standard from the rules on perfidy. And what I mean by that is there's something conspicuously absent with respect to the rule of perfidy. The rule of perfidy is, quote, acts inviting the confidence of an adversary to lead him to believe that he is entitled to or is obliged to accord protection under the rules of international law applicable in armed conflict. In other words, it is perfidious to pretend that one is incapacitated out of woundness or sickness. It is perfidious to pretend that one is surrendered, or to use a flag of truce. But there's nowhere in the at least textual definitions of perfidy is there something about it is perfidious to pretend that one is defenseless or unable to resist. And the standard by the ICRC in part is that if the target is defenseless or unable to resist, then there's an obligation that they're protected. So you would think you would find that embedded in the rules on perfidy, but you don't find that. So I think that's a third area that deserves exploration at the least. Now let me describe what I think are the strengths. And as I've already given away, my conclusion is that the ICRC might be making a leap in their guidance, but it's not as far a leap as one otherwise might imagine. The first is just that the criticism is overstated. The criticism, for example, from Hayes is that the ICRC's guidance on this point is, quote, ill-constructed theory, its ill-constructed theory is flawed beyond repair. The historic consequence of combat is that combatants lawfully may kill their enemies, end quote. And then he drops a footnote to that and says, quote, as the Dutch international law scholar Hugo Gracius stated, in general, killing is a right in war. In other words, once one is liable to attack, as a direct participant in hostilities is, then they're fair game with respect to the right to kill them. And there's no force continuum obligation that applies on the attacker. So I think, first of all, I want to just analyze some of the general structure or architecture of LOAC and argue that, in fact, that claim can't be supported. In the general structure of LOAC, there are restrictions on the ways in which individuals are killed or if they are killed, even if they are otherwise legitimate military targets. And then I want to talk not about generalities, but about specific rules and applications of principles that would go very directly to the point of the conclusion by the ICRC. So in terms of the general structure and somewhat more in the generalities, obviously there are rules that limit who can be killed or how they can be killed, even if they are a combatant. There are limitations on assassination, killing or wounding treacherously or perfidiously. Now one might say that those rules are of an instrumental and practical value because they held up the other rules of law so that we know that actors are engaging in good faith. So they have that instrumental and practical application, but I do think that there's also certainly an element of military honor that goes into the background for those rules. And they're related to the same idea that there are restrictions. A second area of the general structure is that if an armed force in the field comes upon combatants on the other side that they apprehend but are not able to detain, they don't have the capacity to detain them, they cannot kill them. They have to let them go, which is a remarkable compromise and was heavily controverted at the time in Article 41 of the Additional Protocol. In other words, they must release combatants if they don't have the capacity to detain them. They can't just kill them. The third one, that's the counterpoint of that in a certain sense, is that the captured soldier who tries to flee captivity, killing that individual when they're fleeing is considered to be an extreme measure and should be preceded by a warning. So, which is fairly remarkable that you'd have to warn somebody that you're about to shoot to kill them. And that's Article 42 of GC3, which says that, quote, the use of weapons, especially against prisoners of war who are escaping or attempting to escape, shall constitute an extreme measure, which shall always be preceded by warnings appropriate to the circumstances. Finally, the law of reprisals. So, as one might know, if there's an avenue in which or an area in which reprisals still exist, they are against combatants. And so maybe superfluous injury and necessary suffering could be a legal form of reprisal to suspend that rule. But even reprisals against combatants must satisfy standards of a last resort and necessity. So let me now just describe some of what I think are more specific rules or applications of principles that go more directly to the conclusion reached by the ICRC. And the three that I want to highlight are superfluous injury and unnecessary suffering, second, the definition of hors de combat, and third, the definition of military objectives. The first is the definition of superfluous injury and unnecessary suffering. It's an accepted maxim of the law of armed conflict that the right of parties to the conflict to choose methods and means of warfare is not unlimited. The St. Petersburg Declaration, which we generally refer to as the first source or articulated source for this understanding, is that it's perfectly legitimate to use overwhelming military force to incapacitate the other side and to disable as many members of the armed forces of the other side, but it is not a legitimate form of warfare to render their death inevitable, which is also a remarkable constraint on killing. So the prohibitions against dum-dum bullets and undetectable glass fragments do seem to be inconsistent with the critics' harsh contention that once one is liable to attack, it's a right to kill them. You would think intuitively, and I actually thought intuitively, my first intuition would be, well, if they can be killed and the idea is to disable them from being on the battlefield, then all the more power to the attacker to use a form of weaponry that will ensure that that individual never returns to the armed forces of the other side. So why not make their death inevitable? Part of the answer is principle of humanity articulated through those rules, is my understanding of it. And the International Court of Justice obviously argues in the nuclear weapons case that this has independent force, the superfluous injury and unnecessary suffering standard. The second is hors de combat, the definition of hors de combat. This doesn't find a place in the ICRC's guidance and is not in Nils's reply, but I think some more attention should be given to what is the definition of hors de combat. Once an individual is hors de combat, then they're obviously not subject to attack. And the question is, or the contention I would make, is that there's very significant support for the idea that even a combatant who is rendered defenseless or incapable of resistance should not be attacked, and they therefore should be, could be potentially wounded, but otherwise just incapacitated through detention or being held in custody. The ICRC's commentary on the provision of the additional protocol is very specific to this. The idea is that even a combatant doesn't have to surrender. It's outside of the issue area of surrendering. Independently of surrendering, a combatant would be considered in the power of the adverse party and therefore hors de combat, not subject to attack. So the ICRC's initial commentary on additional protocol 1 is directly supportive of this. The quote is, one part of the quote, but it goes on at length, it's not just a snippet, is that, quote, land forces might have the adversary at their mercy by means of overwhelmingly superior firing power to the point where they can force the adversary to cease combat. A defenseless adversary is hors de combat. Second is the Botha treatise. Supports this directly. It says, quote, under customary rules, protection from attack begins when the individual has ceased to fight, when his unit has surrendered, or when he is no longer capable of resistance, either because he has been overpowered or is weaponless. And I understand that these are controversial, but that's pretty solid support, the ICRC's commentary in the Botha treatise. More recently, in the Harvard Law Review, Jack Goldsmith and Curtis Bradley, both who had just served in positions in the Bush administration, wrote an article on the interpretation of the AUMF, and in it, they also supported directly the same line of analysis as the ICRC commentary and the Botha analysis. The quote from them is, quote, a potential consequence of the AUMF's applicability in the United States is that in some circumstances, it might authorize the President to target and kill persons covered by the AUMF found in the United States. Several factors may qualify this conclusion with respect to covered persons in the United States who can be arrested through normal means and do not otherwise present an immediate threat. The laws of war may require a belligerent, even when targeting a legitimate military target, to avoid unnecessary violence and suffering. This principle might preclude killing a non-threatening enemy combatant who can easily be arrested without the use of force. Furthermore, the laws of war prohibit the targeting of persons who are out of combat. And I think what is being envisioned there is Padilla stepping off the plane in her hair. The last part that I think supports the hors de combat is U.S. military manuals to some extent, with a major qualification. The Commander's Handbook on the Law of Naval Operations, 1987, Section 11.8 reads, very much in line, it is as though Botha wrote the statement. Combatants cease to be subject to attack when they have individually laid down their arms to surrender, when they are no longer capable of resistance, and there's the key phrase, when they're no longer capable of resistance, or when the unit in which they're serving or embarked has surrendered or been captured. That language has been removed from the most recent manual, but I would suggest that the international standards are far in favor of keeping that language, and the language that's in the most recent handbook is just at a more general level. It just says individuals who have been rendered hors de combat. So someone begs the question, and I would say this definition fills that in. Third and lastly is just the definition of military objective. I think that there's a good argument that could be made. Cal Chauvin makes the argument rhetorically in the American Society of International Law Proceedings that Article 52 could be interpreted to mean that when there's no a definite military advantage to killing an individual versus just wounding them or taking them out of combat through detention, then therefore there's no direct military advantage to killing them. It's not a legitimate military purpose to attack them through lethal force. I think that's also interestingly consistent with the St. Petersburg Declaration, at least the French version, which says that the only legitimate object which states should endeavor to accomplish during war is to disable the greatest number of men. But the French version is to mettre hors de combat, to make them hors de combat. But the idea would be if they already are hors de combat, there's no longer a military necessity to do something more than that. The last point here is just a puzzle. If the principle of necessity is applied in this circumstance, it might go to the question of level of responsibility. The idea here is that it might be fair for soldiers on the ground to use military force that they consider necessary with the information that they have at their disposal. But if the state is responsible for having created the conditions, the foreseeable conditions that put them in that situation in which force becomes necessary, it might be the state's responsibility and a violation of this rule. Hayes talks about, in part, the McCann opinion, and Françoise might, I imagine, will speak about this, might speak about this as well, by the European Court of Human Rights, in which the court determines in an instance that soldiers on Gibraltar that attacked and killed terrorist suspects were not themselves liable because they perceived it to be necessary. But the state bore responsibility because, as the general rule of necessity of articles of state responsibility in criminal law, tort law, wherever you may find it, says you can't claim necessity if you yourself created the condition that gives rise to the situation of necessity. And in that instance, the British government knew the identity of the individuals and didn't stop them at the checkpoint, when it clearly had the ability to stop them at the checkpoint. So it created the condition in which force became necessary, and a lethal force became necessary. The normative question is just the one I would end with, which is, if this is indeed not such a leap, it may actually just be a step from where the law is to where the law should be, whether or not we should make it, especially if we're talking about contexts in which use of armed forces and use of armed force is more like the law enforcement, and the law and the administrative burdens or practicability questions are not as dire. Also, the level of responsibility question goes to the normative question. The last point I would want to make on that are two hypotheticals. There was a recent news report by Reuters which suggested that the use of drones by the U.S. Administration is being conducted at a heightened level because, according to people who didn't go on the record by name, there was no attribution directly, because we have no place to put them, was the idea, that we have no place to put the individuals because of the rules that have been set against Guantanamo and the like, so our only choice left is to kill. And I think that raises some of the normative questions that one might then think, how should the law respond to that kind of a situation? Or another hypothetical might be to not take the facts as they were with the flotilla incident on May 31st, but to invent some facts, just to tweak them a little bit. If, in fact, the Israeli government had given its soldiers, instead of paint guns and small firearms, AK-47s as their only source of a weapon to board the vessel, would that therefore mean state responsibility that created the conditions in which it was foreseeable that the only use of force would be something overwhelming? Those would be some of the normative questions that would be raised, and we'd try to think about the ways in which the rules might want to measure up to our normative intuitions.
Ryan, thank you very much indeed. That was a real tour de force. If I can simply defend the UK manual for a moment, as the current general editor, and this is news hot off the press, last night I signed off on the latest amendment to the UK manual, in which, Nils, we have brought the definition of military necessity into line with the NATO definition, in order that it now says what it actually means. There's another article for Nils to write. We'll now pass straight over to Blaise Cathcart.
Thank you, Charles, and a very heartwarm thank you to Dennis and the Naval War College for giving this opportunity to me. I realize there's a reciprocal nature to this. I'm jumping in to kind of address my former bosses, Brigadier-General Ken Walken, retired, his comments regarding DPH and his article in the journal. But I'll also I try to inject as much as I can in the short time for preparation my own view on it. I'll characterize, I guess, perhaps unlike some other panel members we've heard, is perhaps more of a focus on what I'll call a current practitioner's view of DPH. For those who are not familiar with the Canadian structure, I'll just take a quick moment, Charles, if you don't mind, just to introduce sort of the structure, so it'll put in perspective, I think, my comments as we go through this topic. As the Judge Advocate General, it's an executive appointment. It's an order and council appointment by the Cabinet in Canada. There are only two in the Canadian Forces. One is myself, my position. The other is the Chief of Defence Staff. And by statute, under the National Defence Act, the Judge Advocate General, and by extension, the officers working in the office of the JAG, provide advice to the Minister of National Defence, the Canadian Forces, and the Department of National Defence on matters of military law. And I also have a slight other important day job is to superintend the administration of the military justice system, which is a challenge in itself. But that's important because in terms of the role, because by extension, the folks who work for me provide legal advice to those players, and in particular on the Canadian Forces side to commanders. Now, many in the room are familiar with that process, so it's not new to you, but in the context of Canada, I think it's fair to say it's a bit of a unique role up to my level because we don't have that civilian level of a legal advisor in between. So, why is that important? You say, so what, Cathcart? It's because of the direct access I have to both the military chain of command and ultimately the policy political chain through the Minister of National Defence. And so when we look at issues, a lot of armed conflict, IHL issues, it's myself and my folks. And just for currency in terms of facts as well, I've got 7 folks currently deployed to Afghanistan, many of whom are providing direct advice to our commanders over there on these very issues. Having said that, as Dennis said earlier, these are my personal views. Because it's an executive appointment, in the English tradition we refer to it as hired at Her Majesty's pleasure. I don't want to displeasure Her Majesty with any undue comments, so I'll try to be controversial given the afternoon, but I can't guarantee it. In any event, the topic, as I looked at it, civilianization of warfighting and the concept of DPH, and Charles already alluded to it in his introduction that clearly in the modern battlefield, theater of operations, it's almost trite now to say it's very complex, both a warfighting and a security environment. And particularly complex for the individuals who are tasked on the state's behalf to go and use military force on behalf of the state to resolve the conflict or the security situation. And in that context, we're seeing, obviously, as has been stated by many authors, a growing number of other players in the battlefield. Number one, and importantly, is who the enemy is. Who is the state sending us to kill or capture? In a traditional sense, they would be distinguishing themselves, and we distinguish ourselves. And as Charles alluded to, there could be bystanders with tea and crumpets watching the battle. Not so these days. Even bystanders could be considered suspicious in terms of the modern concept of the battlefield. And we have a number of different players who are not necessarily the enemy, but because the enemy doesn't distinguish itself from the civilian population, it makes it again difficult in terms of advising commanders and ultimately soldiers, sailors and air persons as to who they should be able to target. And that's really what we're talking about, and my piece will focus on. Unlike Ryan, who dealt with the use of force issue, which is very controversial, agreed, Ryan, and we can have differing views. My focus really on that aspect of who can the troops target, who are civilians who are afforded the protections, particularly not to be targeted, that's the key one, and who are those that lose their protection. And it's clear to say, again, it's a challenge from not only a legal perspective, but the policy and operational perspective. Because we're dealing with, as a legal advisor, I roughly describe my role as the strategic level legal advisor. We have those at the operational level and, of course, at the tactical level in the field, as I mentioned, with our troops currently in Afghanistan. And so we have to have a consistency of approach from the political and policy direction within the rule of law, of course. And I underline that. In all seriousness, that the Canadian Forces certainly conducts all of its operations within the rule of law. The challenge, of course, is always determining and interpreting what it means to Canada and the Canadian Forces, what the rule of law means at a particular given moment in time. And as I said, it's incredibly complex when you're starting to, from a position where you don't know, as you would hope to know, precisely who the enemy always is. Certainly from 9/11 onwards, where Canada also in self and collective defense launched military troops to Afghanistan under Operation Enduring Freedom to fight alongside Americans and others. Certainly as policymakers, operators, and legal advisors, the number one question is, well, who is the enemy? Who is the Taliban? Who are Al-Qaeda? And I think what became quite clear, perhaps more in this context than a traditional distinguished, or a force that distinguished itself, is the heavy reliance. And I'd ask folks to take point or take note of this point from an operational perspective: heavy reliance upon intelligence. And when we talk about the review and Nils's work and the guidance and his retort, a fair comment often is, okay, if you criticize my view, what have you put in its place? And one of the criticisms that Nils put forward about General Watkins' comments was that he didn't really offer a clear alternative to the IG's perspective, and also within the alternative that was loosely described, as Nils says in his article, the criteria, specific criteria for determining who can be attacked from General Watkins' views weren't particularly laid out. Obviously, I can't speak in detail for General Watkins. I know fairly well what he thought, especially when he was my boss. But I'll leave that to another forum. I'm sure he'll have plenty of opportunities here to explain it. All I can simply say is I know from him and from our own discussions that a criteria that is clear for us in the military context is the intelligence factor. Yeah, you really have not much else to rely on, frankly, when an enemy doesn't distinguish itself, but to have the best intelligence you can. That's from your own forces, obviously, but also in coalition operations from that. So from my perspective, intelligence becomes a huge driver in terms of the ability to determine criteria for who is targetable. I think most are familiar with the specifics in terms of the law, primarily derived from Hague, Geneva Conventions, and additional protocols. And in particular, Additional Protocol 151.3 and Additional Protocol 213.3, which talk about what we'll call the DPH rule, that is, civilians shall enjoy protection afforded by these parts unless and for such time as they take a direct part in hostilities. And again, it's a subset of this very same initial question about who are the enemy, who are the civilians that we have to protect, and the soldiers definitely have to be aware of that through the rules of engagement of who not to be able to engage and those who they can engage. And what does a subset of that, what does 51.3 and 13.3 mean in the context of international, non-international context or conflicts? The answer, obviously, as a legal advisor, I have one. I can't fully disclose it here, unfortunately, in that sense. I can certainly say again that the issue is not as, I think, complex, and I say that with respect, Nils, because I do consider your work to be serious work and good work. But at the end of the day, a guidance that is designed to bring clarity, not only for operators, but for others, but from an operator's perspective, the main purveyors of the use of force, the explanations of who becomes a civilian targetable under the guidance is very complex in my mind. And frankly, as someone whose job is to take all sources of information, and obviously law, but information like the IG, and to try and operationalize it and distill it down for the troops, I still struggle even today in preparing for this to fully understand the logic and ultimate framework of the IG study. Sorry, when I say IG, interpretive guidance, not Inspector General for the American context. When we boil down that, troops are pretty familiar from their training and their education that when you go to armed conflict scenarios, for simplicity's sake, and obviously from a legal perspective there are nuances and technicalities, but from a soldier's perspective, we're really talking about how to distinguish between those who fight and those who don't. Others have referred to it, Derek and Ryan in articles, the distinction between combatants and civilians. And frankly, when you're dealing with soldiers, my experience has been that they understand those concepts very well in terms of their training and the ability to react quickly on the battlefield. The challenge for those to assist the war fighters and the soldiers and their commanders is helping them to understand exactly, again, what is or who is a combatant. And doesn't become easier when you have 9/11 events and the development and the evolution of law, both customary and through state practice, of distinctions like unlawful combatants, unprivileged belligerents, lawful combatants. But I think it's fair to say for a soldier that as long as they understand the difference between a combatant and one who's not, the odds of making an erroneous or arbitrary decision or mistake, in my experience, has been that the soldiers don't do that. They are human, of course, but through the training and education that they get, the understanding of a combatant is quite clear for them. The difficulty becomes when there are legitimate debates, as through the ICRC study, or through jurisprudence from domestic courts or international courts, that cause at least lawyers to have to go back to the proverbial drawing board and determine if the assumptions and directions that we provide to commanders through advice are indeed still current and accurate. And that has been the challenge, and one where I personally, and I apologize from my opening remarks, I did not add that between 2003 and 2005, Nils might remember better than I was actually part of the working group meetings in Geneva on the DPH study. So I'm familiar with certainly the front end of the direct discussions we had, Nils. And why that's important again is, you know, certainly from a Canadian perspective, while we are appearing in our personal capacity like today, although the uniform tells you different, our thinking, quite frankly, was why not be a part of a process that frankly is necessary. When you're trying to decipher what does direct participation in hostilities mean, I think it's much more valuable to be part of a process, a legitimate process, to try and help practitioners and ultimately soldiers discern that. And through that process, we're identified the various aspects. Unfortunately, I'm sure we can spend the entire first day, if not all 3 days here, talking about DPH by itself. So I won't do justice by going through the entire IG perspective. But those areas that, from an advisor's perspective and helping ultimately the soldier make those often split-second decisions, are the concepts of individuals, and this is the part, Nils, I refer to that it's a bit tricky for me to follow, and that could be just Blaise, but I think it's shared by others. Individuals who are formed as part of a member or become members of groups, organized armed groups, is the general terminology that you've used, versus those who are acting literally individually on a sporadic basis. That's the difficult position. I agree fully, as I think General Walken did, that the concepts are very good in the sense that the recognition that particularly in non-international armed conflicts, or indeed in international armed conflicts that have groups that are non-state entities, that there is a recognition by significant experts and certainly the ICRC that people can be considered groups. And as General Walken points out in his article, his paper, which I think is a fair comment, that you know, armed conflict and war fighting is really about group activity. It's a collective activity. It's extremely rare. I'm no student of history by any stretch of the imagination, but I'm not aware of armed conflicts that you have you know, 10,000 individuals running around fighting their individual wars. So it really is a group activity, and I think it's on the right track for sure for the ICRC to recognize that concept. However, the but factor is how you determine membership in that group is what has been problematic. And I say problematic, again, Nils, from my perspective, is a way in which we can distinguish for people who are war fighting in a reasonable fashion what those criteria are. And in particular, and I know General Walken has pointed this out, and others have alluded to it earlier, differentiating those who are, I think, the obvious choices. People actually have weapons or bombs, et cetera, in their hands at a particular moment in time. No debate about that. But certainly those support functions, whether combat support, service support functions. Again, it's an area where I think General Walken articulated well that the IG study, I think, the way it's worded in the sense that you have to have the direct connection between those support people and, I think, an act of participating in the continuous combat function, if I could use that term again, for support people is ambiguous at best, and I think unfairly characterizes, or I shouldn't say characterizes, unfairly describes a group of people that I think are logically targetable, certainly when you analogize with a state's armed forces. And again, this is a concept of folks on the logistics, intelligence worlds, for instance, who wear uniforms in state armed forces. If you have those people who are not directly providing an act, an integral act, from an IG perspective, they're not targetable. The so what factor for me in that analysis, and this is, again, I guess one of the chief problems, Nils, and Ken articulated it, is by moving a group of people away from an analogy with state armed forces and placing them more in the sphere of being civilian. I think that makes it tougher, again, for soldiers on the ground to logically and reasonably make that distinction, particularly in close combat scenarios. And then also I think when you combine it with sort of a reliance, generally speaking, to have people, members of these groups, be actually actively participating in a given act at a time, like the placing or detonation of IEDs. If you take that step, you often put the soldier and the state's forces in a position of being thoroughly reactive. And again, from experience, soldiers were responding in reactive fashion in stressful scenarios, don't make the perfect decisions or sometimes even the best decisions, and that's what we're trying to eliminate from a risk management perspective. You watching my time there, Charles? Am I okay? How much more time?
You're okay, at least
5. 5, oh, okay. So again, that was one key area, certainly from a practitioner's point of view, and again, I think we could have many more hours of discussion in detail about the concept of organized armed groups, which I think is a good first step, but the membership piece is still problematic. The other part of the puzzle that we're trying to sort out is the infamous revolving door phrase, which Nils and the ICRC actually refer to as not a malfunction of the law. That was, I think brought up during the various discussions in the working groups, Nils, and I think many of us, certainly on the practitioner side, as military legal advisor, disagreed then, and we disagree again today, that the concept of revolving door really does exist in the way in which the IG describes it. And again, particularly when you're trying to disseminate between perhaps those, I think, rare cases when an individual actually, for some bizarre reason, sporadically takes up arms, other than the levy en masse concept, which I'm a young guy, so I don't remember the last time there ever was a levy en masse. But outside of that context, the individual folks and how a soldier could possibly determine whether that individual by that act is certainly acting alone, sporadically at that moment, or in fact is doing a contribution to a continuous combat function in an organized armed group is again very problematic. And frankly, 9 times out of 10, I think the solution from a combat perspective is intelligence. If you have enough intelligence to make that determination, then it's easy for the troops to make that decision. If you don't have that level of sufficient intelligence, then you're into an area where the doubt rule may come in, and we certainly, from a Canadian perspective, respect the doubt rule. The doubt rule being that if there is a doubt that the person is civilian, you give them the benefit of being a civilian, and we certainly train and educate our soldiers along that very lines. But the creation of doubt through, again, some of the guidance that the ICRC has put out, in my perspective, is not helpful. And that's an area, again, between the membership piece and the individual who sporadically takes up arms. And that goes back to the revolving door issue that I just mentioned, because, those of us who have been around these discussions for many years, there was one individual who always gets a lot of attention in these types of discussions, referred to as Bob the truck driver. And I guess I'll maybe not so uniquely introduce Fred the farmer, because the farming industry, of which Canada is a proud supporter of, seems to be picked on with the farmer by day, fighter by night constant analogy. I guess again from a fighting perspective and the ability to translate the rule of law for troops to actually complete a successful mission, to try and articulate that farmer by day and fighter by night rule to straight-faced into a soldier is extremely difficult. And I doubt that there are many soldiers that would accept that as a realistic view of the battlefield. Of course, not all soldiers are schooled in the law, and we help them, but I think that's a fair reflection that the law, in my opinion, does not hold that the revolving door actually exists in the way in which the IG describes it. And in fact, if you take that revolving door concept, you tend to, again, create this sense, which is a common thread, I think, through the IG, that the end result often, if you try and base it on the dealt rule particularly, because your intelligence is always not going to be strong, you're going to be constantly increasing from our perspective and expanding the pool of people who are protected by civilian status, who often should not be protected by that status. So that's a challenge which we welcome certainly IG's perspectives on that, but again, it's just not clear for us how we can translate that into to soldiers. Quickly, with a few minutes left, Charles, I'll just try to wrap up, and I apologize, it's been a bit over the map, but that's because, frankly, that's, from my perspective, trying to knit together the various comments made in the IG. And I note, Nils, in your response to the articles, you described it as the package deal. I understand the concept, but it's very difficult to deliver that package deal, frankly, to soldiers and through a training and education purpose. It's not insurmountable by any means. We continue to take what's good from the study and incorporate it into our education training process. But to take it as a total package, I think, is not workable. In fact, it's probably more advantageous to break the better parts down out, even the ones that we're critical of, and deal with it that way. At the end of the day, too, Nils, the IG report, I think, suffers a little bit from, and we've heard a lot today, even from the use of force discussions from Ryan, is a heavy focus on what we call the tactical level. It's really, it's important. Obviously, we're talking about troops who are pulling triggers, who may kill individuals in theaters, but that focus on whether the individual, the enemy who is a member of a group or acting individually in a sporadic moment, is focused on a physical act of participating in hostilities, doesn't translate into, as you go up the chain through the operational and ultimately the strategic chain. Because much like a regular armed force, our organized armed groups do have a structure in which strategic decision-making is done, and also operational decision-making functions like intelligence, for instance. And again, from our interpretation, it's difficult to separate that the focus is so much on the tactical that I think it doesn't fully account for those members of the groups who are working at what we would analogize with as the strategic or the operational level, which again excludes, in some cases, a large amount of the organization that the state has sent us to fight against. So I'll be hopefully really brief in my concluding comments that seriously, I do believe that the IG report is a step in the right direction. I do believe there are positive aspects, such as the three cumulative elements, Nils, for determining participation in hostilities. But as Mike Schmidt also alluded to, I think there's much debate to still be made about what actually should consist those elements and other aspects of the IG report. And at the end of the day, from my perspective, as I started out with, saying that we're talking about a legal officer and legal practitioners trying to do that balance of military necessity and humanity under often very complex and stressful circumstances. We have to be able to deliver to the troops something meaningful that makes sense. Obviously, it's legal within the rule of law, but there is an element that there has to be a reasonableness, and and troops in the modern forces also have an element of a moral certainty about their actions and their activities. And certainly from a Canadian perspective, none of our troops are trained in any way, shape, or form, and generally speaking, except for those who do human things, are never interested in wanting to capture or kill, importantly, any person who's rightfully protected underneath the law. So at the end of the day, the IG work is good. It's a good start. I think there's much more work to be done in realistic terms. And ultimately, no matter what the documents or the law come up with, certainly as a legal practitioner, we're dealing with the armed forces. There is no substitute ultimately for education and most importantly, training of the troops. We can have the most articulate and well-written guidance or rules of engagement for that matter, but without having the troops be able to operationalize it in their minds. And again, I think that's where the IG falls a bit short for being useful at that level of training and education. I'll leave it at that for now, Charles.
Thank you very much, Blaise, and thank you too for standing in at such short notice. I will go straight on to Françoise Hampson.
Thanks very much. If I could have the PowerPoint, thanks. First of all, I'd like to say what a privilege and pleasure it is to be back in Newport, and I'd like to thank Dennis and his staff at the Naval War College for giving me the opportunity to participate. My comments on DPH and the interoperability of the law of armed conflict and human rights law are specifically related to targeting and opening fire and not other issues that are a problem in the two areas. Why am I choosing to look at this issue? Well, it's because the relationship between the law of armed conflict and human rights law is still being worked out. So I think it's important to examine the implications that the DPH debate has for that working out. Since the parameters of the debate were established notably by the International Court of Justice, all the running has been made by the human rights side of the argument. I think it's particularly important that the military should join in, because otherwise there is a real risk of solutions being adopted that are of very considerable inconvenience, to put it mildly, to the military. It is not a form of joining in to take indefensible positions. You actually need to consider where the debate is and what positions can possibly be maintained. And in that context, I will be advocating a particular solution. But in order to get there, I need to look at some of the background to the rules. Next slide, please. And I'm going to proceed on the basis of assumptions, because I want to get to the substance, so I can't spend the time looking at these preliminary issues. The first assumption is one that is supported by absolutely overwhelming evidence, and that is that the applicability of the law of armed conflict does not have the effect of turning off human rights law. In other words, there are circumstances in which both, whether you like it or not, are applicable, and that is no longer a battle that is worth fighting. The second assumption is an assumption from purely the area of human rights law. It isn't a law of armed conflict issue at all, or about the relationship. There is still genuine debate about the scope of extraterritorial applicability of human rights law. There is no debate that there is some extraterritorial applicability. The question is how much. Some of the areas seem to be settled. For example, stable occupations, I think one should insert stable, and extraterritorial detentions seem to have been accepted as having human rights law applicable in them or to them. The question, which is particularly relevant for targeting, is in other areas. The third assumption shouldn't be a problem at all in relation to this audience, but would be a problem with various human rights audiences. One needs to consider what the function of the law is. It seems to me that the law is the bottom line, and that isn't the same thing as military common sense. And the gap between the legal bottom line and military common sense may be considerable. Either in policing operations there is no gap between the two, that the law is in the same place as policing common sense, or if there is a gap, it's quite a small gap. And so I think one needs to remember, I mean, a military audience doesn't need to remember the gap between the two, but when one's considering the interoperability of the law of armed conflict and human rights law, one does need to remember that this is a concept you're going to have to sell to the human rights lot. In other words, just because you need an authority that you, in a particular environment, doesn't mean you will invoke it in every situation within that environment. But that doesn't reduce the fact that you actually need that global authority in the environment. The classic example would be inappropriate Chapter 6 mandates when you really need a Chapter 7 authority, and that you end up with more casualties, more civilian casualties, if you've got an inappropriate mandate. Therefore, it's absolutely vital that the human rights crowd understand that that is a military necessity, this possible gap, and it doesn't mean you're always going to be operating at the extremes of your authority. The fourth isn't really an assumption, it's an issue. In the first half of the 20th century, it was not surprising that states worked on the basis that when there was an international armed conflict between two states, that it affected the two territories completely. that was a necessary part of the whole concept that underlay international armed conflicts. Once you get into non-international armed conflicts, the issues are rather different. And I have the impression that perhaps the assumption that it involved the whole territory of the states in question was transferred across to non-international armed conflicts without adequate thought. Since then, the additional Protocol 2 threshold, and particularly the case law of the International Criminal Tribunal for the former Yugoslavia, calls that assumption into question. I don't think it's surprising that it's called into question in non-international armed conflicts, because domestic rules on emergencies and human rights law would also suggest that there should be some confining of the applicability of LOAC to the territory where the fighting is happening. So I would suggest that in non-international armed conflicts, LOAC will be applicable to those areas where, and at those times when, an armed conflict is taking place, and to conflict-related issues elsewhere. Let me give an example from the case of Northern Ireland. Let us assume, which is not the official government position, but then I'm not on the payroll of the government, let us assume that at certain times the conflict in Northern Ireland crossed the threshold of Common Article 3. That only meant that LOAC was applicable in Northern Ireland, not that it was applicable in England, Wales and Scotland. But it would also have been applicable to detentions in Manchester, London, Birmingham, anywhere, that were directly related to the conflict. So I think the geographical limitation of LOAC rules in non-international armed conflicts, I'm emphasising that, does, I think, make sense, and it's certainly something that, within the limits of which I think the military can work. It will also make easier, but it's not a sufficient reason for adopting it, the interoperability of the law of armed conflict and human rights law. I suspect that the nature of international armed conflicts means this principle will not apply there, but I can think of some situations where there might be an exception. Next slide, please. Also, as part of the background I need to clear, I want to consider three distinctions. The distinctions themselves are not controversial, but I think the issues that are involved in the distinctions are at the root of the problem of the interoperability of the law of armed conflicts and human rights law with regard to targeting, particularly in non-international armed conflicts. The first is the distinction between Hague law and Geneva law, or Hague-type rules and Geneva-type rules. Intellectually, the distinction is accepted, I think, by all armed forces, but it seems to me that in military thinking of states, particularly those that have ratified Additional Protocol 1, they've merged. Just because Additional Protocol 1 contains Hague-type provisions and Geneva-type provisions doesn't mean they've been merged. It simply means it contains examples of both. I don't actually think you can merge them, because I would maintain that Hague-type rules and Geneva-type rules work in significantly different ways. Next slide, please. In the case of Geneva law, the focus is on the victim. Geneva law is based on the result to be achieved or avoided. It's not based on a balancing act in the mind of the decision maker. It's just identifying that which is prohibited or required. It's possible to take that approach to the issues that Geneva law addresses, because largely Geneva law operates away from the battle space, and it doesn't interfere with the conduct of military operations. Hague law is very different. It identifies the competing elements that the decision maker has to take into account. The focus is on the decision maker and not on the victim. The focus is on the decisions and not on the result of the decisions. And we need to remember, and I think in particular human rights groups need to remember, that proportionality is a Hague law principle and not a Geneva law principle. What's more, the protection of civilians under AP1 doesn't mean that civilians are protected persons in the same sense as the categories of protected persons in the Geneva Conventions. It operates in a different kind of way. Of course, feasible measures are to be taken to protect civilians, but they're not subject to the same type of regime as the Geneva Conventions categories. This is important, I think, because everything to do with targeting or opening fire against persons in the law of armed conflict is part of Hague law and not part of Geneva law. And I think that human rights groups in particular tend to confuse Hague law and Geneva law, or to apply Geneva law notions to what are Hague law problems. The second distinction is between treaty law and custom. Next slide, please. The fact of the distinction is obvious. It's very clear that in treaty law, Hague-type rules only exist in international armed conflicts and those non-international armed conflicts that cross the AP2 threshold. There are no Hague-type rules between Common Article 3 and the AP2 threshold. Even with regard to conflicts, non-international conflicts across the AP2 threshold, there are very limited Hague-type rules. In effect, it's you can't target civilians, and some other rules on things that you can't target. But it's a very, very limited menu of treaty rules that look like Hague-type rules. One exception to that is said to be rules on weapon use, which are said nowadays to apply in both international and non-international armed conflicts all the way down to the Common Article 3 threshold. The rationale is superficially attractive. What is inhumane in an international armed conflict must be inhumane in a non-international armed conflict. What is indiscriminate in an international armed conflict must be indiscriminate in a non-international armed conflict. However, I think it is important to remember that expanding or dum-dum bullets do have an extremely useful role to play in specific law and order environments. So you don't want the law of armed conflict to be applying there. Similarly, tear gas is a better agent of riot control than live ammunition, as Turkey discovered in the Guleç case in the European Court of Human Rights. In relation to those weapons where it's already been established that any prohibition or regulation applies in both international and non-international armed conflicts, I don't think so far there's a problem. But I do think one needs to watch the generalization that just says that all rules on weapon use apply in both IACS and NIACS. But with that possible exception apart, the position is that under treaty law, there are very limited provisions of Hague-type law, and they only kick in across the additional Protocol 2 threshold. Geneva law is very different. That starts being applicable at the Common Article 3 threshold, which is generally regarded as a pretty low threshold. And I think that's a good thing that Geneva law kicks in at that threshold. So I'm not for a second suggesting that should change in relation to Geneva law. We need to remember when looking at appropriate legal frameworks that it's not simply a matter of looking at what suits particular states at particular times. One needs to look at what the situation is globally. Globally, the majority of non-international armed conflicts are Common Article 3 conflicts that don't cross the threshold of Additional Protocol 2 and that don't involve any state other than the territorial state. To end up drafting rules to deal with transnational NIACs involving NATO states, I think would be an inappropriate way to proceed for the drafting of rules. So in terms of treaty law, Hague law kicks in at the AP2 threshold, but Geneva law kicks in at the Common Article 3 threshold. What about customary law? Next slide, please. If customary Geneva law is very like customary treaty law, I don't think there's a big problem. There's certain areas where there's a bit of difficulty, for example, some of the modalities to do with detention. But generally speaking, if there is a close parallel between treaty Geneva law and treaty customary law, I don't think there's a problem. Where there is a very real problem is in the relationship between treaty Hague law and what's alleged to be customary Hague law. And the biggest problem area is in non-international armed conflicts. I don't think there's a huge problem in international armed conflicts. The discovery over the past 15 years of what's alleged to be huge swathes of customary Hague rules, which has been discovered to be applicable in non-international armed conflicts, and which more recently has been embedded to some extent in the ICC statute, has not been accompanied by any reflection on the scope of applicability of customary Hague law. I've just pointed out that treaty Hague law only applies at the AP2 threshold. Nobody seems to have asked the question what the scope of applicability is of customary Hague law. The ICRC study, for in my view very understandable reasons, did not look into that question at all. If it had, it would have taken another 20 years, would have been infinitely more controversial, and I don't know it would have resulted in any publication at all. So I can understand why it didn't look at it, but it does mean that that question hasn't been looked at least there. The assumption seems to have been made that once it was established that something was customary in NIACs, it meant it was customary in all NIACs. That seems really remarkable when you consider that states have gone to the trouble to distinguish AP2 NIACs and other NIACs for the purposes of Hague law in treaty rule formation. So it seems to me strange that no distinction has been made. It may be the case that looking at the text of what the ICRC was looking at when it did the customary law study, it may be that there no distinction was made between Common Article 3 and AP2 NIACs. However, I suspect that if they'd looked at the context out of which the state practice arose, that context might well have restricted some of the things that are thought to be customary in NIACs, might have restricted it to AP2 NIACs. Similarly, the ICC statute treats all NIACs in the same way and does not make a distinction between Common Article 3 NIACs and AP2 ones. So this means that under customary law, but not under treaty law, an armed conflict paradigm is thought or claimed to become applicable for decisions on targeting once you cross the threshold of Common Article 3. Now that is going to pose very real problems for the interoperability of human rights law and the law of armed conflict. Because at present, if you just look at the treaty law paradigm, because there are no Hague-type rules between Common Article 3 and AP2, a law and order paradigm would apply to decisions on opening fire. So the assumption that customary Hague rules apply in a Common Article 3 context is displacing what is at present a law and order paradigm. And one reason this matters is because under a law and order paradigm, the rules on targeting depend on behavior, never status. Whereas under the law of armed conflict, a status behavior counts, but in addition, you can target by reference to status. And that's where there is an issue with the DPH study, because the DPH study has moved from what was purely originally a behavioral test, in fact, to a combination of behavior and status. Next slide, please. The literal meaning of unless and for such time as they take a direct part in hostilities, whatever the words mean, is clearly a behavior test. Once you've got a category of people who can be targeted because they're members of a group exercising continuous combat function, you're determining that you can target them by reference to their status and not merely behavior. That's fine if you're operating in a law of armed conflict paradigm. It's problematic if you're operating in a law and order paradigm. So the DPH study has raised a new difficulty in the interoperability of the law of armed conflict and human rights law because of this insertion of a new status category. What does human rights law have to say about the basis for targeting? Next slide, please. I've had to split the slides between everywhere except Europe and Europe. The one international text, International Covenant on Civil and Political Rights, the American Convention on Human Rights and the African Charter on Human and People's Rights prohibit arbitrary killing or arbitrary deprivation of the right to life. Now, that has the advantage of giving the decision-making bodies flexibility, because what's arbitrary in peacetime might not be arbitrary in time of armed conflict. However, the way in which the case law has been interpreted, both by the Human Rights Committee and the American Commission and Inter-American Commission and Court of Human Rights, suggests they will take a strict view on when deprivation of the right to life is or is not arbitrary. In other words, they're going to need something to get them out of a law and order paradigm. But the treaty text gives them flexibility. That's not the case with Europe. Next slide, please. And you can blame the Brits for this. The Brits were responsible for the drafting of Article 2 and Article 5 of the European Convention because they said they didn't understand what was prohibited by arbitrary killing. Therefore, they wanted an exhaustive list of the circumstances in which you can use potentially lethal force. So Article 2 of the European Convention is exclusively based on a law and order paradigm with no flexibility for shifting to any other paradigm. The only way you can move into an armed conflict paradigm is if the state invokes Article 15. That enables either as a derogation or as a defense the state to invoke lawful acts of war. No European state, even though many have derogated, no European state has ever yet derogated in relation to Article 2 of the European Convention. And it would need to be invoked in order to trigger this. So it looks as though the starting point of human rights law is based on a behavioral test. There have got to be definite specific grounds to do with someone, for example, threatening others, someone threatening to kill themselves, someone running away immediately after the commission of an offence, although it looks from the Strasbourg case law as if that would no longer be a ground for opening fire. There's that, and it's got to be absolutely necessary to open fire. And it's subject, in Strasbourg at least, to very, very strict scrutiny. So the starting point of human rights law appears to be based on the behaviour of the person targeted and not on a status test. Next slide, please. So then we need to consider on what targeting is based under the law of armed conflict. Most of them are status tests, not all. A combatant is targeted by virtue of his status, and unlike the comment this morning, as far as I'm concerned, when a member of the armed forces is asleep at home, whatever he's doing during an armed conflict, he can be targeted. It also applies to a militia satisfying the four requirements of Hague 4 Article 1, which is most unlikely to arise. I'm glad that Blaise mentioned levé en masse, because to be comprehensive, I thought I should mention levé en masse. An individual civilian in an international armed conflict taking a direct part in hostilities can be targeted by virtue of their behaviour. In a non-international armed conflict, a member of an organised armed group exercising continuous combat functions is targeted by reference to status, and a civilian individually taking a direct part in hostilities can be targeted by reference to behaviour. So it would look as though, for status-based targeting decisions to be lawful, the law of armed conflicts is going to need to be able to trump human rights law. So the question is, in what circumstances can the law of armed conflict trump human rights law? Next slide, please. Here we've got some evidence from the ICJ. The ICJ has said that human rights law applies in all situations subject only to derogation. And it said that where the law of armed conflicts is applicable, then it's the lex specialis, but it hasn't explained what that means. For example, it's not clear whether you only look at treaty law or whether you look at customary law. It's not clear at what thresholds you start applying the lex specialis. It's not clear how human rights bodies are to use the fact that the lex specialis may be applicable. And there is a very common real problem before human rights bodies when they're dealing with armed conflicts that are across Common Article 3, but probably not across the AP2 threshold. And that's the problem of states denying internationally that there is an armed conflict. They have a problem of criminal behaviour or of terrorist behaviour, but they haven't got an armed conflict. And in some cases, states making those claims won't even derogate under human rights law. So the United Kingdom and Turkey both derogated with regard to Northern Ireland and the situation in southeast Turkey. They derogated with regard to the length of period of detention and grounds of detention. But Russia has not derogated at all in relation to the conflicts in Chechnya. Now, there might be an argument that when the law of armed conflicts is applicable, but a state chooses to be judged by a higher standard, the standard of human rights law, it's free to be judged by that standard. What I hope human rights bodies will not be tempted to doing is to giving the impression that the applicability of the law of armed conflicts depends on what the state says, because the applicability depends on the facts. So I think there's a danger there that could be avoided by simply saying they're choosing to be judged by a higher standard. So how are we to put together this human rights approach based on behavior, which can be displaced when you can invoke the lex specialis, and if you displace it, you can then get status-based targeting? I think that there are 4 possible options. Next slide, please. Don't panic if you don't have the time to read this slide, because the next slides actually unpack this. So I will move straight away to the next one, because it's going to reproduce that text. So the options 2 slide, please. What are the objections to using the law of armed conflict instead of human rights law in both IACs and all NIACs, so anything across Common Article 3? I think the problem there is that if you were to allow customary Hague rules to apply once you cross the threshold of Common Article 3, that you would actually aggravate the conflict, because the state would then be operating a military paradigm rather than a law and order paradigm. It's likely to lead to higher levels of civilian casualties. I mean, you only have to think about something like Bloody Sunday. And it's not going to assist in the process of finding a political solution, because situations across Common Article 3, but not across the AP2 threshold, are usually ones in which you can't get a purely military solution. Nor can you get the military simply creating the changing the status quo ante, which presumably is what operates in an international armed conflict. So I think the objection to using LOAC and specifically Hague customary rules, or what's alleged to be Hague customary rules, once you cross the threshold of Common Article 3, is it will make the situation worse. Now the next option, next slide please, which is an objection to using LOAC only in cases of international armed conflict. I think it's clear that certain non-international armed conflicts, and I would include Afghanistan, characterized by the degree of violence and or the number of opposing forces and or the type of weaponry used and or the nature of the operations undertaken, can't appropriately be viewed as a form of policing. A policing paradigm would be inappropriate and too restrictive for the state. And as I said earlier, it seems to me that when forces can only use a policing paradigm when they need a law of armed conflict paradigm, that also results in increased casualties in the longer term. And I think that's a problem for the UN when it decides whether to give Chapter 6 or Chapter 7 authority to peacekeeping forces. So I think the danger in being too restrictive with the lex specialis and the danger of being too generous with the lex specialis is in both cases it doesn't suit the situation and it results in a higher level of civilian casualties. Next slide, please. What about the possibility of only using the lex specialis doctrine in relation to treaty law provisions of the law of armed conflict and not customary law? This isn't as objectionable as the first 2 suggestions, but I think it would be a shame to lose a significant quantity of non-controversial customary law. I mean, for example, if you had someone firing over a white flag, it seems to me that's so much entered into the public way of doing things. There's even an example of that in Bloody Sunday, when it was a situation that was at that time not characterized as an armed conflict by any of the relevant parties. But it's just seen as a universal symbol, the white flag. And to ignore the fact that there's some non-controversial rules of customary law is, I think, a pity. So it would be, I think, too limiting to say we'll use the lex specialis doctrine, but only in relation to treaty rules. So what about the 4th option? Next slide, please. That would be an objection to using LOAC rules only where AP2 is applicable to the conflict. So you'd use LOAC as a lex specialis, but only when the conflict was across the AP2 threshold. That means you're losing the benefit of Common Article 3 between Common Article 3 and the AP2 threshold. And I think that would be a potentially significant loss. I know that Dave Kretzmer has suggested that humanitarian law, as he called it, should only start at the AP2 threshold. When you consider the states that haven't ratified certain human rights treaties, when you consider the fact that under Common Article 3 there's a prohibition of discrimination, whereas the discrimination clause in the European Convention on Human Rights is potentially derogable, I think it would be a shame to use Common Article 3. So I don't think the lex specialis across the board should only kick in once you cross the threshold of AP2. Next slide, please. So what is my proposed solution? I'm only proposing this in relation to targeting and opening fire, and I'm assuming that the law of armed conflict will only apply to those areas in a territory where an armed conflict is occurring or to related issues elsewhere. Where the law of armed conflicts is applicable, targeting or opening fire can be based on status, even, therefore, under human rights law when you're applying the law of armed conflict as the lex specialis. Where human rights law is applicable, such decisions can only be based on behaviour and where there's no alternative, e.g. arrest. So you've got this, status will kick in with LOAC, behaviour for human rights law. So what's the solution? Next slide, please. The first bit, in an international armed conflict, the law of armed conflict will be used as a lex specialis in relation to targeting, opening fire decisions, full stop. No qualification to that. That would apply to both treaty and customary law of armed conflict provisions. Next slide, please. In non-international armed conflict situations and areas where the level and nature of the violence is such that AP2 would be applicable if it had been ratified, then the law of armed conflict should be used as the lex specialis in relation to targeting and opening fire decisions. That would apply to both treaty and customary law of armed conflict provisions. In other words, under human rights law, a killing would be lawful under human rights law where the situation was one across the AP2 threshold and the killing was compatible with the law of armed conflict. Therefore, it would be possible to use a status test. Next slide, please. In other non-international armed conflict situations, that's to say below the threshold of AP2 but across the threshold of Common Article 3, human rights law will be used to determine the lawfulness of the decision to target or open fire, because that's a Hague-type rule, and any other issue under Hague law, but the law of armed conflict will be used as the lex specialis in relation to Geneva law type issues, and that would apply to both treaty and customary LOAC provisions. Next slide, please. That does mean that when the law of armed conflicts is not applicable, only human rights law will be applicable. So if you have got a member of the CIA or a member of the US Armed Forces in Pakistan who intentionally kills a Pakistani, then I think that under international law principles, since there is no armed conflict between the United States and Pakistan, that would be analysed in terms of human rights. The lawfulness of the killing would depend on the behaviour of the individual. Let me, in two concluding sentences, make clear where I think the price of the battle that is to be fought, the price if you don't sort this one out. What I'm suggesting is LOAC as it stands. So, of course, in LOAC you're entitled to shoot to kill. I'm not taking the same position as Ryan there. I'm taking it for granted that once the law of armed conflicts is applicable, there's an entitlement on the part of a member of armed forces to shoot to kill those whom he's entitled to shoot. There's no need to attempt to arrest, I would suggest, under the law of armed conflict. Now, if you want to maintain that, if you want to maintain those things as they currently stand, then I do think you've got to accept that below the AP2 threshold, LOAC will not be the lex specialis except in relation to Geneva law. If you don't accept that issue of the threshold, then I think you are going to find human rights bodies making inroads and insisting that you've got to arrest if you can arrest and all this kind of thing. You've got a choice between whether you look at the threshold or whether you look at the incidence of combatant status. You're not going to be able to win both. I am aware of the fact that what I am proposing has got implications for the responsibility under international criminal law of non-state fighters. They would, of course, remain responsible under domestic law. And finally, as you'll have seen from the PowerPoints, I'm suggesting that under customary law, the threshold of applicability for additional Protocol 2 may be more flexible than it is under AP2 itself. I think what matters is the nature and form of the violence. I don't think that control of territory would necessarily be a vital ingredient under the customary AP2 threshold. Thanks very much.
Thank you very much indeed, Françoise.